So the third panel is entitled The Future of Litigation Strategies, and the moderator is Darrell Miller. Darrell is the Melvin G. Shim Professor of Law and Associate Dean for Intellectual Life at Duke University School of Law, as well as the co-director of the Duke Center for Firearms Law. Before arriving at Duke, Darrell clerked for Chief Justice Guy Cole of the U.S. Court of Appeals for the Sixth Circuit. He practiced complex litigation in Columbus, Ohio, and was a professor at the University of Cincinnati College of Law. Darrell, as with the others, will be introducing his panelists, but before I turn it over to Darrell to introduce his panelists, I want to take this opportunity to thank all the participants in today's conference, our co-sponsors, our moderators, and all the participants who gave up their afternoon to be with us today. With that, I will turn it over to Darrell to introduce his third and final panel.
Thank you, Peter, and thanks for inviting me to moderate this great panel. I'm really excited about it. As Peter said, I used to be in litigation not nearly as long as our panelists, but have the privilege of teaching civil rights litigation as well as civil procedure here at Duke University, and I'm always interested in how the sausage gets made, as it were, and we have a great panel that can give us that sort of granular sense of how do you actually litigate these cases and what the future will be in this space. Our first panelist is Chris Boning. He's a partner at Paul Weiss in New York, where he's worked there for over 25 years. Chris worked with the Brady Center to sue gun sellers in Texas and has written in opposition to PLCAA, the statute that we talked about many times already this afternoon. Prior to joining Paul Weiss, he attended the Washington University School of Law, where he was editor-in-chief of the Washington University Law Quarterly and was elected to the Order of the Coif. Our next panelist is Evan Chesler. Already mentioned, he's the chairman of Cravath, which he has worked there since 1976 and has been a litigation partner at Cravath since 1982. He's the head of litigation since 1996 and a presiding partner since 2007 and chairman in 2013, and has won just about every litigation award that can be offered and is routinely placed at the very top of the list of top litigators. He's a graduate of NYU Law School and graduated Order of the Coif and clerked for Judge Isner Wyatt in the Southern District of New York. Professor Troy McKenzie is a professor at NYU and has been there since 2007 with a brief stint as the Deputy Attorney, Assistant Attorney General in the Office of Legal Counsel. Prior to joining NYU, Professor McKenzie was a litigation associate at Devoice and Plimpton and clerked for Judge Pierre Laval on the Second Circuit and Associate Justice John Paul Stevens at the Supreme Court. He's a 2000 graduate of NYU Law School. Erin Murphy is a litigation partner at Kirkland & Ellis in Washington, D.C., where she's argued 4 cases before the Supreme Court and where she represents the National Rifle Association among many other top clients. Prior to joining Kirkland & Ellis, Erin worked at Bancroft PLLC and King & Spalding, and she has clerked for Judge Diane Sykes on the Seventh Circuit and Chief Justice John Roberts at the Supreme Court. She's a graduate of Georgetown Law School. Our final panelist is Hannah Shearer. She's the litigation director at the Giffords Law Center in San Francisco, where she coordinates major firearms litigation, including the 2019 NYSERPA versus the City of New York case. Before joining the Giffords, Hannah worked at Munger, Tolles, and Olson as a was a law clerk to Judge Paul Watford in the Ninth Circuit and is a Stanford Law grad. So, like I said, this panel is organized around sort of thinking through and pulling in connections between the prior panels and the on the ground issues about litigation. So the first question, and maybe I'll direct it to Aaron, is this issue that has come up in our panels prior about the sort of methodology of the Supreme Court. As many of you know, the Supreme Court, the lower courts, excuse me, in Second Amendment adjudication have adopted a two-part framework. The first part tends to be very scope, category oriented, and very history heavy. The second portion of the framework tends to be more conventional scrutiny, analysis, and tailoring. And so for Aaron, the question about this is sort of history, especially to the extent that we might see a Kavanaugh-like text history tradition only approach, is a real question about, like, how do you get that kind of material? What are you looking at? Where do you get it? How do you know what you're reading? I'll be frank, like I didn't know until graduate school that if you looked at something prior to 1752 and it said a year, it might be a year that changed over on January the 1st, or it might be a year that changed over on March 25th, depending on what part of Europe you were in. So how do you, get the material, and how do you know what you're looking at?
Sure. So, it's a great question, and I'm going to start by noting, I mean, the way courts approach all of these issues, and we'll talk a little bit about this, but this whole kind of methodology is very, very much in flux. So it can depend quite a bit on the court you're before, the case you have, the type of topic, how much it's been litigated somewhere or not, how much the courts are really going to focus on all this. There's many cases where courts have said kind of, we'll just assume the history away and not really resolve it. So there's sort of a first cut challenge of where are you litigating, who are you litigating before, what is the approach that they want to think about? And I think you're absolutely right to note that, I think the Supreme Court has perhaps expressed a little more interest in a history and text-based tradition than some of the lower courts are applying right now. But obviously the Supreme Court hasn't told us a whole heck of a lot in this area for the past decade or so. So all of that is a little bit up in the air, but, I think that, some of it is a first cut of, as a litigator, you absolutely rely on the academics who have the ability to really be digging in kind of with the leisurely, a little bit more time on their hands than you sometimes have when you are in the midst of a case. You may have kind of just a little bit less of that capacity to do all that. And so there's a lot of wonderful scholarship that's been done over the past decade. And really, this is one of these areas where I think the scholarship and the jurisprudence is sort of developing hand in hand. You kind of see as certain issues start to come up, you can look at something like the issue of whether there's a right to carry a firearm outside the home. And in the earliest cases that dealt with that, there was almost no discussion of history. And in the more recent cases, there's a ton of it. And that's in part because, the litigants and the scholarship have focused more and more on that as the issue has been litigated more and more. But so, I think you look to a lot of different sources. Obviously you gotta start with primary sources, but it's a little harder to find all of those when you are dealing with stuff from a few hundred years ago. And so when you don't have some scholarship that's already been done, you look for the laws where you can find them. You look for the case law. I think case law is tremendously important because one of the important things is situating the history in context. It's very easy to take something out of context or to look at some language and take it out of context. And sometimes looking at the cases and the way that certain laws were, even if they weren't being directly interpreted, being understood, or sometimes, you're looking for things like the dog that didn't bark, where you have a certain type of law and a debate about what that law meant, and you look for cases whether that law was enforced a particular way or not. Sometimes you're going to be looking more broadly, because a lot of these things, if they were going to court, they were at kind of like a municipal level where you wouldn't really have a judicial decision created. Sometimes, what you end up looking at is scholarship, in terms of the scholarship, is looking at things like public accounts, newspaper accounts and things to see where you're seeing people having been arrested or not arrested for certain crimes. Is a statute one that was never mentioned for 200 years. So then you start to think, okay, maybe it didn't quite mean as much as someone thinks. So I think part of the challenge is, you know, of course you have that, how do I just locate old things, looking through old collections of statutes, looking through old collections of case law, looking through all of that. But then, you know, I think that it's absolutely equally critical, if not more so, to take what you find and put it in that context and look at what can we see to get to the question, not just of whether we can point to some law that sounds like maybe it's relevant, but that we can find evidence that that's the way it was understood, that that's how people understood that law, that that's how courts understood that law, that that's how that law was enforced. So I think you really got to look to all those different pieces to try and get that full story and make sure you're not just kind of doing, you know, a little bit of a history light sheet on all of it.
Does anybody else want to weigh in on this history question?
Daryl, I just wanted to say briefly that the Second Amendment is one of those odd areas in which the historical resources are actually very deep. The court generally has taken a turn in the last generation towards a greater use of historical sources because of the importance of original public meaning. And the rise of originalism more broadly in constitutional interpretation. And one of the criticisms that is often used, I often use this criticism when I speak to my students, is, you know, lawyers and judges aren't historians. They don't really have the resources to go in and do a deep dive into history. And so you get a kind of a botch job when there's a turn to history. But going all the way back to even in the 70s and 80s, when there was a beginning of academic interest in the Second Amendment, including Professor Sandy Levinson's influential article in the Yale Law Journal about the Second Amendment, I think it was something like the embarrassing Second Amendment, which, you know, first indicated maybe there is an individual right, which was not the kind of the settled understanding at that time, at least. And you go back and look at that article, and there's lots of reference to historians and other academics plowing the fields for historical resources. So it's one of those areas in which there is a lot of material. And I think, as Aaron indicated, the harder question is how you sift through and contextualize that material. Not just a snippet of text here and there, but understanding, for example, how a regulatory scheme worked in 1790. But it's different in some ways from other areas of constitutional interpretation, where the usual criticism of originalism as, you know, dime store history or law office history doesn't quite have the same sting.
Daryl, if I can just add one point to what Troy just said. You know, I went back the other day and reread Heller. And I have to say, not being an expert in the area, but having read an awful lot of cases over the years, you read Justice Scalia's opinion and his use of historical sources. And then you read Justice Stevens' dissent and his use of historical sources. And I, for one, am at a loss to figure out who had it right. They both have enormous amounts of material that they've obviously had their law clerks plow through and that they are purporting to interpret. And yet they come to diametrically opposite conclusions about the same 30 or 40 words. And one concluding that the introductory phrase is not a limitation on the rest of the amendment language, the other coming to exactly the opposite conclusion. So while I see that they have a lot of material at their disposal, and I'm sure that they read it and their law clerks applied rigorous discipline to trying to contextualize it, it's pretty remarkable that 9 justices split 5-4, both parties purporting to rely upon deep historical precedent, both purporting to contextualize it, and yet coming out in completely opposite places. So I come away from that process saying, I'm not sure this works as an intellectual exercise because there's no way to check it. It's sort of like fact checking a presidential debate in real time with no internet. You know, you're kind of floating along in a very large ocean on a very small boat. Just my reaction to it.
Daryl, if there's time, I wanted to add that I think even if this is an area where there's quite a large volume of source material, I still think there's institutional challenges for courts to know what to do with it. And maybe it's a methodological challenge in that it's really not clear under current Supreme Court precedent what to do when there's regional differences in how laws were adopted, or if there's a dearth of information about how laws were enforced. And so I just think that there's issues, even if there's a lot of historical source material to pull from.
Can we put the second part of the two-part framework on the table as well, right? So, you know, we've talked a little bit about the challenges about how to do this sort of history-intensive first part, or what some justices have at least suggested might be a history-only analysis of Second Amendment claims. But the current two-part framework also involves some kind of traditional scrutiny, which might be more familiar to many of you in the constitutional litigation domain. Tell me a little bit, and maybe I'll direct this at Hannah, sort of some of the methods or challenges in doing that part, that is showing the government interest, showing the tailoring. My recollection was that in New Jersey, for example, there was some challenge to a regulation that was not supported by evidence, but that was, of course, before there was a right. And so there was some concern that the factual record about why you had the regulation at all wasn't supported in an environment in which nobody thought there was any problem with passing this kind of regulation. So how do you practically manage these kinds of challenges when litigating the scrutiny stage?
Thank you. And just to provide some context for my work in this area, I have focused on drafting and coordinating amicus briefs in major cases on behalf of supporters of gun safety laws, including many briefs focusing on the second step, detailing the social science evidence in support of important gun policies. And coming at it from that perspective, we see a tension in these cases where challengers are demanding at the second step something like a very high level of certainty, statistical certainty, a completely on point social science study justifying a law that may be 100 years old, as in the New Jersey case that you referenced, Daryl. And I don't think that's right. And I think that's because, while Heller left a number of unanswered questions about, as we just talked about, how to evaluate history, and also what form of heightened scrutiny is appropriate and when. Once courts actually get to the heightened scrutiny stage at the two-step framework that's the consensus approach in the lower courts, there's tons of precedent on that for analogous constitutional rights like the First Amendment. And those precedents don't say that a legislature has to have statistically conclusive evidence about the value of a law. There's an acknowledgement that there may not always be an on-point empirical study. I think for very old laws, that could be the case. But there's also an acknowledgement that legislatures should be allowed to experiment with new solutions to serious problems. And that's a point that the Supreme Court referenced in McDonald. So I'd suggest at the second step, courts and then also the legislatures passing these laws don't need to look for an on-point statistical analysis if there isn't one, but could instead look for things like policy research, testimony from public safety officials, or inferences from similar types of policies that show either the tight fit that's demanded under strict scrutiny or the reasonable fit demanded under intermediate scrutiny. So I would challenge the idea that social science evidence needs to be a huge hurdle at the second step for older laws. I'd also argue that forms of heightened scrutiny that exceed what's done in other constitutional cases that demand statistically certain evidence of effectiveness, that could be difficult. Under that standard, it could be difficult to justify very new gun safety legislation that's responding to current events. Think about the shutdown orders at the start of the pandemic that affected gun stores and gun licensing while the medical evidence was in flux. And so I would hope and argue that heightened scrutiny should allow for this kind of action during a evolving crisis, instead of requiring there to be an unrealistic level of statistical proof in favor of a policy when that's not demanded in other constitutional contexts.
So if I could just weigh in a little bit from, just for context, I am always on the challenging the laws side of this litigation. So so from the challenger side perspective, I mean, I don't think anybody's demanding anything. We'd be happy to have anything that's even close to the scrutiny that you get in other contexts. But I really think in most cases, it's very rarely going to turn either on the strength of the government's interest or on whether a law does something to further that interest, because in every case, the government invokes public safety. And in every case, challengers generally agree, of course, the government has a compelling interest in public safety. And, unless you have like a really irrational law, which, to be clear, I think there have been a few over the years, but, most laws do something to further public safety. And so to me, what really should matter in the scrutiny, and what matters in other contexts in the scrutiny, is the fit. And by fit, I mean, have you chosen means that don't go kind of out of their way to impose the greatest burden possible, and instead actually try to accomplish the government's interests in ways that endeavor to not infringe to the greatest extent on constitutional rights? And that's really, where most cases are going to turn on that analysis, on that question, that if you were in the First Amendment context, say, you'd ask, okay, we get it, we get why you're doing this, but do you really need to infringe on this much speech to accomplish that objective? Or are there ways that are, if you're in strict scrutiny, are you in the kind of the least restrictive means? If you're in intermediate scrutiny, are you in less restrictive means areas? I mean, the court has said repeatedly in the First Amendment context that even in intermediate scrutiny, you need narrowly tailoring. And so I think it's not really, to me, about needing some kind of statistical thing that shows that this law kind of does precisely what you set out to do. It's about that question of, okay, we can all agree, let's agree on a legitimate end. Have you chosen a means that's really, even if it's not the absolute necessary, that's on the kind of higher side of necessary to accomplish that end? Or are we giving the government just kind of leeway to do anything it wants because we're worried about gun violence? And I think, that's really, to me, what the debate is about when it comes to determining the appropriate methodology, if we're going to have kind of a tiers of scrutiny based methodology rather than a text, history, and tradition based methodology.
Anybody else on the panel want to weigh in on this issue? I mean, one thing I think, in fairness, my recollection was, this problem in constitutional litigation is not unique to the Second Amendment, right? So in the same-sex marriage litigation, there was lots of debates about proving up the harms, even though the regulation had been put in place before anybody thought there was an issue. And so it's one of the persistent, fascinating things, at a step removed as I am as an academic, about how constitutional litigation actually gets made is some of these sort of questions that we're addressing here. Troy, I'm interested, your thoughts and the panel's thoughts on this a little bit more sort of institutionally based, right? So Aaron, typically is on the sort of gun rights side. Hannah is on the gun violence prevention side, and yet there's all kinds of coordination issues. Not everybody, if you're on the gun violence prevention side, you're not, there's many different groups. Some states and some legislators might have their own agendas that they want to pursue in litigation or not. If you're on the gun rights side, you don't control whether criminal defendants who might be unpopular or unsympathetic are bringing Second Amendment defenses to prosecutions. So how do you think through some of these coordination issues when we think about the entire field?
I speak as an unfrozen caveman academic because I don't write about the Second Amendment, and I haven't litigated about it. But I teach procedure and teach a Supreme Court seminar where one of the things we talk about with students is how cases are framed and litigated, both in the lower courts and also when they get to the Supreme Court. Interestingly enough, one of the things that made the greatest impression on me when I was in law school is having a professor for criminal procedure who talked about the downsides of, this was touched on earlier, the exclusionary rule, the downside of litigating Fourth Amendment issues in the context of criminal cases, because you typically have, frankly, unsympathetic invokers of the right. You have a criminal defendant who is invoking a right, and usually the right will end up favoring someone who is highly unsympathetic, and that's generally not a good way to frame any issue. That's what you tell any law student about litigating. It's better to have a sympathetic plaintiff with good facts, or a sympathetic invoker of a right with good facts. The other is resources. That it's especially in litigation where you might have the government will be on the other side. You typically want to have, if you're sort of pursuing a right, you want to have the best resources on your side. And to the extent that these issues are litigated in say, the criminal context, that may not always be the case because of the realities of who may end up defending a criminal defendant. If you sort of think back to the Miller case in the 1930s, that's one criticism of Miller, is that it was sort of, the Second Amendment argument was thrown up there as part of a criminal case and wasn't truly litigated and fleshed out in a way that kind of got down to the heart of the question. And Justice Scalia, I think, relied on that to sort of distinguish Miller when Heller was decided. Having said all of that, I'm not really sure that has been true in some of the recent Second Amendment litigation. And I say this several years ago, actually right after Heller was decided, I was on a panel with Alan Gura, who argued Heller. And one of the things that struck me is that he indicated during the panel that that litigation was not initially championed by the NRA. It was sort of litigation that was brought by a couple people, including Gura, who were really interested in the issue. There was another plaintiff who was perceived as being much more sympathetic. No one with a criminal record or anything like that, but they kind of went off anyway and ended up succeeding in the Supreme Court. And I suspect that has been the case. I don't know, but I suspect that has been the case more often than we might like to acknowledge, that you can sometimes have relatively unsympathetic plaintiffs who are pursuing these claims and end up succeeding anyway. And once a case gets to an appellate court, or certainly the Supreme Court, the amount of amicus brief support, the amount of attention the case can bring, I suspect will equalize the resources to an extent that might not necessarily be the case in other types of contexts where these issues can come up with, the generally unsympathetic party raising the constitutional right. So I'm going to just throw out the maybe counterintuitive argument that it might not matter that much in Second Amendment litigation, maybe at least today. And maybe I'm completely wrong about this, and I definitely defer to the I see Aaron smiling. I defer to the litigants. I just wonder if it matters. And just to end on this, in preparing for this panel, I read now Justice Barrett's dissent when she was a judge on the Seventh Circuit in a case that it presented the question whether someone who was who had a felony conviction for I think it was for tax fraud, whether that person could challenge the federal statute that limited her ability to keep and bear arms. And my initial reaction was, well, this is, there's no way this litigation will get anywhere because, a convicted felon, apart from the language in Heller, boy, that's the most unsympathetic type of party you could get pursuing that claim. And yet, Barrett's dissent, is a kind of a pretty dispassionate analysis of the question, goes to history, pulls all of that out. You don't get the sense that, you know, there's any kind of sheepishness or tiptoeing around the fact that the party in question is someone who has a felony conviction. So I almost wonder whether it will really matter in Second Amendment cases.
Although, Troy, it was a dissent.
Yes, it was a dissent.
I do think, I mean, a lot of the Second Amendment litigation is affirmative litigation. And so, you know, I mean, in almost all of the cases that I've done are affirmative litigation where we picked plaintiffs, and, you know, usually it's just like anybody would go about any other civil rights litigation. You know, you have an associational plaintiff, like, you know, someone like the NRA or sort of the state organization like New York State Rifle and Pistol Association in the New York case. You have individuals who want to exercise the rights, and, you know, there's that. I think most folks are picking, you know, finding pretty good folks to be the plaintiffs, the individual plaintiffs in most cases. So I think when you look at like the cases that, I mean, it's hard to say that really successful cases because there's so few successful cases in Second Amendment litigation these days. But the ones that I think of as, you know, kind of the major cases, the ones that at least are generating dissents, that are kind of, you know, a lot of that is affirmative litigation. And I think the other place where there's been some success are along the lines of then Judge Barrett's dissent cases that are a little more as applied, you know, or that even if they're not, you know, that they're either really as applied, as we've seen with some of the cases involving individuals who have, often in the mental health context, who have kind of, you know, they were hospitalized when they were 16 and now they're 45 and have been perfectly well-adjusted people all their lives, but have a permanent bar on exercising Second Amendment rights. Or what I think of the tax fraud context as sort of like an as-applied variant of the felony question. So I do think your instinct has proven, you know, in the sort of mine run, just criminal defendant raising a Second Amendment challenge to something that's always been criminal, you know, those have not, I've seen very few of those get very serious attention outside sort of the misdemeanor context, which is a little bit different.
I've been prompted to make sure that I give everybody that's watching and seeking CLE the code. So the code is CCJFL6. CCJFL6. Evan, how do you anticipate the new personnel on both the lower courts and the Supreme Court will affect this kind of litigation going forward, not only in the Second Amendment domain, but maybe more broadly in other questions that touch on firearms and guns?
Well, I would like to think it will have little effect. I have to say I've argued several cases in the last few months and have been impressed with, unrelated to firearms area, I've been impressed with the level of preparation of the judges in those cases and the sort of straightforward nature of the questions that they asked, which went right to the heart of the merits of the case, which is what you always want as a litigant. But I have to say, in this area where it is so politically fraught, you know, I have to believe that the recent appointments are just, given the odds that you're going to end up in front of a judge who's been recently appointed, given how many of them there are, that it is going to affect the litigation. And I think, to go back to a point that Troy made before, I think that if you're a plaintiff, that ought to be affecting which fights you pick and who you pick to be your champion in those fights. That is, who's the plaintiff that you've picked? Where do you choose to bring the lawsuit? How do you choose to frame the issues? Those are universally applicable questions that every trial lawyer, every litigator faces. But I think in an area like the Second Amendment, and given both its political sensitivity and the change in the sort of, you know, fundamental shift in the judiciary that's taken place over the last 3 years, I think that those choices that are made by litigators every day have to rise to a premium level of importance. And venue selection, issue selection, which hills you choose to die on and which ones you choose to avoid have to become paramount. I also read Judge Barrett's dissent. I think it's a case called Cantor that Troy was referring to. And I was struck in the context of those facts. It was a pretty compelling argument, but one that you have to step back and say, how could that not be politically motivated? To find that in fact, as long as the felony of which you're convicted was not a violent felony, that your right to bear arms should not have been abridged by that conviction. That's my own bias speaking, I know that, but I was surprised. Now, as I said, it was a dissent, so the majority opinion came out the other way. But it does demonstrate that these kinds of tactical factors, Daryl, that your question is pointing to are necessarily, I think, much more important in the current environment than perhaps they have been in the past with respect to the Second Amendment.
Christopher, a question for you, which is, we all have some experience, some more than others, in the litigation space, and settlement is always at the a possibility. It's what I start with in my civil procedure courses. You can always settle a case. You don't actually have to litigate it. So how do you think about the issues of settlement in the future of gun litigation?
So I think it very much keys off of what Aaron and Evan have mentioned. I mean, these are litigations like litigations we handle day in and day out, and we have to approach them as such from the beginning to the end. And settlement is obviously always a tool. As Evan mentioned, sometimes you have to figure out what fights you're going to pick and which ones you're going to pass on. And so there's a place for settlement, not in every case. If someone's intent on trying to take a particular case up, and it's purpose selected, it may be difficult. But for a lot of the litigation that we pursue on the gun violence prevention side, actually settlement gives you more ability to achieve the objectives that you may be interested in. So, for example, you mentioned at the outset that I had been involved in a litigation in Texas about the sale of a firearm that was used in a homicide. After the individual had told the gun shop that he needed the weapon to kill his wife. He didn't kill his wife. He killed his father-in-law just hours after acquiring the weapon. You can get damages, but is that really what you want? And so if you want to reform the sales practices, settlement should be on the table because it might give you, as we were able to do there, an opportunity to work with the gun shop and try and reform their sales practices to spark change in a way that doesn't require necessarily regulation or legislation, but essentially self-regulation where people are voluntarily adopting a series of best practices. So I think settlement has a role to play in this space as it does in any field of litigation.
Daryl, if I can just add something. We're all, as litigators, familiar with Rule 23 and the class action mechanism and the role that the courts play in evaluating class action settlements, which is profoundly different from the little or light dusting that courts often, in some cases, they don't give any attention to it. It's a matter, totally private matter between the litigants. And the court really has no say. Once the parties have decided to settle, they settle and they walk away from court, as opposed to Rule 23. In this instance, though, a lot of the litigation falls into what in California I think would be called a public injunction. That is to say, it's a non-class action, but where the litigation involves a remedy that would have a broad impact on society or on the public. But it comes up in the context not of Rule 23, but of a private litigation between two parties. And I really think that this is a place where there ought to be, I think, some attention from the academic community to add some real rigor to this question, where you're settling a private dispute between two parties, a plaintiff and a gun manufacturer, for example. But the remedy is what might be characterized as a public injunction. Should there be some additional process added into the mix that looks more like a Rule 23 process, even though it's not a class action? Yeah, I remember some years ago, there was a settlement that I think involved Smith & Wesson, between government plaintiffs and Smith & Wesson, where they agreed to a number of injunctive type remedies in the settlement. And there was so much of an outcry over the settlement that they backed away from it, even though it was not done in the context of a class action. As I said, emotions run high on this question. And when there is a public significance to the injunction, and it's not in a situation where people are under the rules able to come forward as objectors, as there would be in a Rule 23 situation, I think it deserves some more scrutiny from the academic community to see if there ought to be some scholarship applied to this question and how one should go about the process of bringing a settlement through to completion where it is a public injunction type remedy.
Could I actually pick up on that? I'm interested, sparked by a question in the chat about as applied challenges. The question was essentially, is the future of Second Amendment litigation just all as applied challenges, in part because of the way in which proof is sort of worked up in particular cases, and that led me to ask, like, what happens, for example, if let's say a municipality or a state as defendant kind of picks off plaintiffs. You know, plaintiff comes along, has really sympathetic facts, would have a very strong as applied challenge. You know, let's say I'm the corporation counsel of a city, or I'm in the state AG's office. You know, can I just say, okay, well, we'll settle and agree to grant you the permit, or let you carry under particular circumstances. We've now gotten rid of your case, kept it from going up to the Court of Appeals or the Supreme Court, and we'll just take them one by one as they come along. And to Evan's point, you know, normally you could get around this on the plaintiff side, typically by using a class action, which keeps the pick off from occurring. But I sort of wonder whether you could certify a viable class action. Maybe for some types of challenges you could. And if this is going to be an issue tactically in future Second Amendment litigation.
Yeah, and you know, it already has been for some time. I would not be surprised to see a bit more of it. But I think the context in which we've seen it the most is, as you suggested, the permitting context. You know, in cases challenging whether you need and whether you can get a permit to carry a firearm. You know, a lot of these regimes, by their nature, have discretion built into them. And so there are a lot of jurisdictions that in sort of the first wave of efforts to litigate those cases would do exactly that. They'd just grant the permit to the sympathetic plaintiff, and you'd have to start all over again. And I think that's part of why, you know, a lot, like anyone who's bringing one of those challenges these days is, you know, if you're being thoughtful about it, you're going to make sure you have an associational plaintiff. And I think that's the main way, you know, that we've tried to deal with that in our cases, is to have multiple individuals and an associational plaintiff. And at that point, you know, I think then it's surprising how, you know, in almost every case you get a standing challenge anyway, one way or another, even just to people who are saying, I'd like a permit, I asked for one and it was denied. There's usually a standing challenge anyway. So, you know, so I do think looking at the recent New York State Rifle and Pistol Association case, I mean, I think just coming at this from the perspective of not just settlement, but also sort of mootness, which is the other side of it. I would not be surprised to see more efforts. Going back to your earlier question about whether the composition of the courts is going to impact litigation, I think in any context where you have civil rights litigation, you kind of have the litigants react to the courts in the ways that they litigate cases. And I don't think it was an accident that New York City spent 5 years vigorously defending the law, then it then turned around and gave up immediately the moment we got to the Supreme Court. And I wouldn't be surprised to see a little bit of that happen in some other cases, but it all depends. I mean, there's some issues that are far too important to states and municipalities that they're never gonna, they may do what they can to keep a particular case or a particular plaintiff from being the one that goes up, but they're not going to change the laws and policies. But I would not be surprised to see that kind of go hand in hand in the coming years if we do, especially if we start to see a renewed interest by the newly composed Supreme Court in taking up some of these cases. That if you look at the history of kind of abortion litigation, any type of civil rights litigation, you can see both sides being very, very savvy and very sophisticated about which cases they try to take up and which cases they try to keep away. And I think we'll see plenty of that going forward.
It's a really fascinating issue, and Troy, I'm sort of glad you raised it. And in some ways, it's the obverse of what Evan was sort of mentioning, which is, what are you going to do? How you do an associational standing when you have sort of bespoke justice on as applied? It's my permit, not that other guy's permit. So you got that issue, and then you have, of course, all the ethical issues about it's your client's case, not your case. It's not the civil rights bar or the movement's case. It's your client's case, and I think that's shared across whatever sort of civil rights litigation you happen to do. This is a question for Hannah and Aaron and maybe Christopher too, about where expert witnesses come into play in this kind of litigation. What do you use them for? How do you find them? Maybe sort of going back to the sort of the history issue. Do you have to certify historians as experts for these cases, or is it usually in some other domain?
Thanks, Daryl. I can start and would be interested to hear from others on the nuts and bolts of finding witnesses and their credentials. But on a higher level, I think that experts enter Second Amendment litigation in connection with steps 1 and 2 of the consensus framework in Second Amendment cases. And so historian experts can help with the first step, and social science experts, medical professionals, law enforcement officers, state officials, other people like that can be helpful at the second step. I think in many cases, firearm hardware experts are going to be relevant, people who can testify about how guns operate, lethality of different weapons, gun training, how guns are used defensively, whatever issues relevant. And I'll offer an additional comment that may be controversial with folks on the other side of the issue, which is one type of expert that I've increasingly seen entering litigation in what I think is a problematic way, and that's the market share expert. In some cases, there's gun industry employees who are produced to say that a particular firearm or accessory has been sold in sufficient quantities so that it's in common use nationally and can't be prohibited, or sometimes can't be regulated by a state. And so just wanted to flag that type of expert as implicating an analytical problem with the version of the test that's proposed in cases that involve restrictions on AR-15s, on 30 or 40 round magazines. This idea that if you show that a firearm is in common use using testimony that could be self-interested from the gun industry, then that severely curtails what kinds of regulations can even make it to the second step of the analysis. So I think that litigators on my side of the issue could do more scrutinizing of those experts, and I'm sure from the other side there would be experts they'd look at more closely too, to make sure their testimony maps on to the Second Amendment test. in ways that are defensible.
I'm sorry. No, go ahead, Erin. Go ahead.
I mean, I was just gonna say, I think, you know, Hannah's hit on the main role. I mean, I find some of it's a little bit funny because it's a little bit different from the way experts get used in a lot of traditional litigation. I mean, you know, there's not a lot of other contexts where you have kind of an expert historian as somebody who's putting in an affidavit, and you know, so it's to me a little different, and so much of the litigation is really about the framing and the framework that you're going to use, and so I think it's the rare case that really kind of turns on like expert credibility in the sense that it would in other types of litigation. It's more kind of what do you amass, and whether you end up amassing that historical record through an expert or somebody else is, I don't think, particularly relevant in the minds of most of the courts. I mean, to Hannah's last point, I mean, on the factual question, I actually think that's an area that makes perfect sense to be putting in, like, you know, to have people who can speak to it as a factual matter in terms of whether things are commonly owned, how many people have them, what they do with them. You know, separate debate we can have about what the right methodology should be for determining what is in and what is out for purposes of the Second Amendment. But, you know, that strikes me as like one of the areas where it actually makes some sense that courts would be looking to kind of a factual record of, okay, who can tell us that? And I do think a lot of that, you know, there's litigation over that. I mean, there's a lot of litigation that's going on, you know, initially with kind of where people would say, oh, well, that might be, you know, you say there's 100,000 guns, but they're only owned by 1,000 people because a lot of people own a lot of them. You know, there's those kind of debates that happen. And I think that the key, you know, in my mind is the more this kind of litigation has developed over the past decade, the more you see people, you know, what I would like to see is just the courts saying, okay, well, why don't both sides prove it? And instead, you know, and that's the way it normally works in litigation, and not kind of, oh, well, you know, one side put in a ton of proof, but the other side came up with like some theory under which their proof might be deficient, so you lose. And that is how it often works. And so, you know, to me, whatever the end result ends up being, I think it's a good thing when the courts are saying, and I think it'd be great if both sides are, you know, putting in that evidence and putting in those facts on the issues here that are factual and that, you know, that matter for purposes of how the court is thinking about what those tests are going to be.
Evan?
I was going to just make a comment about, you know, when you look at the PLCAA and you think about the sort of exceptions that are carved out where you can, you know, pursue litigation under the statute, it raises some interesting questions about what sort of experts, you know, you would think about using. So, you know, it occurred to me there's this recent litigation in Connecticut growing out of that horrible incident of the school children being shot and killed. And it's, you know, it's been moving its way through the Connecticut courts where they're using, one of the theories is a state consumer protection law. You know, I've litigated consumer protection cases, not in the firearms context, but in, you know, more traditional commercial context. And one of the things you often do in those cases is you bring in marketing experts. You do surveys on whether people were deceived, you know, about something that was said in advertising. One of the statutes that I think is available potentially under the federal statute, under the exceptions, is the Federal Trade Commission Act. And when you litigate FTC Act cases, which I've done, you know, you often have competing surveys being used to demonstrate that people were or were not confused, consumers were or were not misled by things that were said on one side or the other in an advertising context. So I think, you know, as people start to think creatively or are thinking creatively about what litigation options they have, I think it opens up the possibility of experts being used who have not traditionally been involved in Second Amendment litigation. And I think, you know, marketing experts for a consumer protection-based claim is probably a good example of that.
So, Evan, I'm co-counsel in that Connecticut case, the Soto case, arising out of Sandy Hook. And I was just gonna say, essentially, we talk about Second Amendment litigation as if, sometimes it's always in the Supreme Court, but as Evan is noting, there are lots of theories and challenges that people are bringing, including like the one we have in Soto, where very traditional damages experts, marketing experts, those sorts of things are part of the strategy. And there's, now there's a petition brought by Brady and the father of one of the girls killed in Parkland before the FTC on this, essentially the advertising theory. And so I do think that is, a rich area that we'll see develop in a very traditional litigation way over time.
Chris, is there an effort to get the case from the Connecticut Supreme Court to the US Supreme Court?
So the case is currently stayed because Remington filed for bankruptcy this summer, but we prevailed in the Connecticut Supreme Court on the unfair trade practices question, where we put in an amicus brief. We began pretrial depositions, discovery, and now it's stayed. But before we began pretrial, there was a petition for cert filed by Remington, which was denied, and so hopefully the case will be put back on a discovery schedule, and the families will have their day in court, and we'll see what happens after that.
Right.
Darrell, I just wanted to mention very briefly that at least on the in litigation challenging state or local regulations, in some of the cases I've read in prepping for this panel, I've noticed that, for example, in the New York City case that the court ended up deciding by per curiam last term, the city had put in a declaration by an inspector, a poor Inspector Lunetta. And, Justice Alito basically plucks apart Inspector Lunetta's declaration in loving detail in Justice Alito's dissent from the per curiam. And I think Judge Bibas in the Third Circuit has done something similar in the New Jersey case, one of the New Jersey cases, because the declaration of the expert or the person who is supposed to come forward on behalf of the government entity, that is really almost like a talking brief about why the regulatory scheme is in place and what it's there to serve. So it's a very strange use of testimony or evidence, because it's like fact evidence that is really about the rationale for a legal scheme. I'm not quite, I guess this can happen in litigation, but it's a very odd kind of confection.
I think I remember reading that as well. And again, just sort of drifting a little bit beyond this, my recollection from civil rights litigation is that police testify as to what happens all the time, right? They're not qualified as experts, but they testify as to, this is a bad part of town, or, when people do this, it usually means they're secreting drugs or contraband or something like that. And I think there was a whole law review article about the sort of sub rosa expertise of police. So it's not just Second Amendment litigation. Erin, did you have a point?
Well, I was just going to say on that, I having argued that case in an earlier iteration, I am rather intimately familiar with the declaration, and my recollection. I guess what I always viewed as the problem with it. I don't think there's any kind of necessary problem with law enforcement being experts in these cases. Of course they have expertise, and they are going to be very qualified to speak to many of the questions, and they actually often speak in, both sides usually have law enforcement amicus briefs and such, and I think they absolutely have a role in a lot of the litigation, particularly when you're talking about these kind of, the kind of cases that are challenging a particular law or regulation or whatever. I think the problem that we've seen in some, and that case began very early. That case started in about 2012. It was one of the earliest cases out there. Is that it used to for many years all the state would do. I mean, they put in a declaration that was about 3 pages long, and it basically just said things like, this law might help law enforcement catch people who violate gun laws, and like that's it. I mean, it didn't say, I have enforced this often. It didn't identify anyone that it had ever been used to find who was misusing a firearm or doing it, or even really identify any experience with having found anybody who was violating the previous law that they said they needed the new one to enforce. So it really was, I think, to Troy's point, like it was just kind of, it read more like, I'm providing an affidavit of reasons that a legislature might want a law like this, which pretty much, anybody could provide that. And that's not kind of what I think of as the role of law enforcement expertise. But I think an affidavit from law enforcement that really speaks to, here's a particular problem we face, here's why this particular type of law has been helpful in enforcement efforts, why this one hasn't been, has a little bit of actual facts and data and statistics. To me, there's nothing wrong with that in the Second Amendment context, just as there's nothing wrong with it in a lot of other, particularly in criminal contexts.
So we got about 10 minutes left. Let me give the code again for those that missed it the first time. The CLE code is CCJFL6. CCJFL6. Troy, so what kind of policy proposals do you see coming out maybe in the next 10 years in this space?
So I think this is an easy one. Not many. That is my profound prediction. So to be less glib about it, I suspect that at least in terms of legislation at the federal level, obviously legislation in this area, in light of the political realities of gun legislation, I don't think anyone should put any money on a bet that there will be broad sweeping legislation. And I don't think this really matters who controls Congress. I just think it's very, very hard to build a coalition that could enact legislation as sweeping as, say, some of the gun control legislation of the 60s or the Brady Bill, for example. At the state level, I suspect that what we may end up seeing is something along the lines of what we have seen since Heller, which is legislation that is very responsive to particular events and particular incidents. And that legislation sometimes is drafted maybe more thoughtfully than other times, to put it diplomatically, because of the sort of catching the moment and responding to a particular incident. What I have thought about, and I don't really know what the answer to this is whether some of the activity will end up moving to the local level, especially in states that allow local governments to have, say, stricter gun safety regimes than the state permits. Not every state allows local governments to do that. And then federal agencies through administrative maneuvers. I mean, the bump stock issue was something that was this administration essentially tried to handle that internally through administrative means. Obviously, the federal government administers the background check system, and may have a certain amount of leeway there. So I wonder if some of the activity will not necessarily be legislative activity at the federal level, but episodic legislation at the state level, maybe the local level, and then more intriguingly and maybe less transparently, administrative changes at the federal level that might address particular kinds of issues that can come up in the parts of the firearms market that the federal government has the most influence in.
Evan, you get the compliment to Troy's question, which is, what is this panel is about the future of litigation? So what is it going to look like? What are the litigation opportunities you see on the horizon?
Well, assuming that the statutory framework doesn't change, because if it does, then all bets are off. But I'm assuming it won't change because it probably won't. I think there are several things. One is the case that Chris is involved in, the Soto case, which has really, suggested in pretty strong ways that the consumer protection statutes, which many states have, is a fertile ground for future litigation. There are a lot of states that have, UDAP type statutes, unfair and deceptive acts and practices statutes. A number of those statutes have sort of dividends that come along with them if you're on the plaintiff side, attorney fee provisions, double or treble damages provisions, the mechanisms for attorneys general to intervene with the private plaintiff. So I think that's a related but perhaps separate avenue for future litigation. I mentioned before the FTC Act, and Chris indicated that there's already some activity at the administrative law level trying to invoke the consumer protection aspects of the Federal Trade Commission Act. I'd make one other point, which is I think litigators appreciate the fact that there's enormous power in discovery, that is itself a very important tool, and often leads to good results for your client, even short of a judge ultimately entering a judgment or a jury ultimately entering a verdict. And so I think what's critical is to be able to survive the motion to dismiss stage, which these consumer protection statutes at both the federal and state levels provide an opportunity to do, because whether or not discovery is stayed at the early phases, there's no stay built into the federal statute, but courts have broad discretion on whether to allow discovery to go forward in the pre-motion to dismiss phase of litigation. So I think it's critical to be able to create litigation strategies that will get over the motion to dismiss hurdle, so that the weapon, if you will, of the tool of discovery, it becomes available in these lawsuits, because that will have, I think, an enormous impact on how these litigations go. If they're shut down at the pleading stage, then nothing much will come of them. If you get over the pleading hurdle, then I think much will come of them. And I think that's particularly important when you look, for example, at the other options, like the public nuisance statutes have gone largely nowhere as a vehicle for this type of Second Amendment litigation. They've been shut down by and large in a number of the federal circuit courts of appeals. I would commend to the audience, Judge Katzmann's dissent in the City of New York against Beretta case back about 10 years ago. It is a very well done explication of how you might successfully make the counter argument. Again, it was a dissent, so it didn't carry the day, but it's a very useful, I think, tool for litigants to look at for future strategy. So I'd focus on consumer protection, UDAP type cases, the Federal Trade Commission Act, creating litigation strategies that will survive a motion to dismiss to be able to get to the discovery stage, because I think that's where a lot of the litigation pressure, if you will, is going to be exerted in the future, and where remedies may be obtained even short of judicially imposed remedies.
And I would just add, Daryl, to Evan's point about the dissent in New York City. There was a recent decision in September of this year from a Pennsylvania appellate court ruling that PLCAA was unconstitutional basically, disagreeing with the Second Circuit's opinion, and so we'll see what happens to that case. The U.S. government has intervened, and I think there will be more folks trying to chip away at PLCAA, which is really a remarkable statute. I do think that we would be better served if we let the courts do their job and deal with ordinary litigation in this space without the blanket immunity that PLCAA affords. That would address, I think, a lot of concerns. The economic power of litigation has helped change a lot of things for the good, and this is an area that kind of calls out for that, especially given that the sort of Second Amendment issue is so polarized. But people, when they're presented with the facts, will reach the right choice.
With apologies to everybody, some really excellent questions in the Q&A. We are at the end of our time.
No. Another hour, please.
This has been a fascinating discussion, and I really am honored to have been able to moderate it and engage with all of you. Really thoughtful comments, and thank you very much for lending your time and expertise on the last panel of the day. And with that, I'll turn it back over to David. Thank you so much.
Thank you.
Thank you, Darren.
Thank you all for coming. Peter, do you have any closing remarks? Yeah, you're on mute, Peter.
You're on mute, Peter.
No, I said I had no closing remarks. I already said what I had to say, to thank everyone for sharing their time with us, and thanked all the panelists and other participants and the moderators. So that's really all I had to say. So that's it.
Yep. Thanks, everybody. Special thank you to Abby and the Solomon Center, Daryl and Joe and the Duke Firearms Center, and to Evan Chesler, whose idea was to have this conference in the first place.
I did want to say, Evan, if you hadn't, you missed my introductory statement about you, which I said that it was basically your brainchild to have this conference. But David just...
Thank you. And David, you've done just a terrific job of gathering together such impressive panelists and moderators who I've been watching, and their expertise is really great. A terrific job for the Center on Civil Justice, as always. And Peter, congratulations, and you're overseeing this whole process. I thought it was just terrific.
Yeah, Evan is a very, very active member of our board, and we appreciate that. As is Troy.
As is Troy. There he is. Thank you. Thank you all very much.
Thank you all. Bye-bye.
Thanks to everyone for being here. I'm going to close out the event. We appreciate it. In the next 24 hours or so, give or take, you should be getting an email with a CLE form, which you'll need to complete in order to get CLE credit. So just watch out for that. Thanks, everybody.